Damn, Lil Durk took some L's today. Presiding the Honorable Michael W. Fitzgerald in chambers ordering denying defendant Dirtbank's motion for a bill of particulars 227. Before the court is defendant Dirtbank's motion for a bill of particulars, the motion docket number 227, which is joined by defendants DeAndre Dontrell Wilson, docket number 247, Asa Houston, docket number 248, and David Brian Lindsay, docket number 249. The court previously denied the motion to the extent it sought to dismiss the second superseding indictment for vagueness. The court nevertheless allowed defendant Banks to file a supplement regarding his motion for a bill of particulars, which was filed under seal on January 5th, 2026, docket number 339. The government filed a second supplemental opposition to the motion on January 23rd, 2026, docket number 349. Defendant Banks filed a response on that shit. And for the reasons stated earlier on the record and also in the government's second supplemental opposition, the motion is denied. Specifically, the second superseding indictment and the disclosures made by the government are sufficient to inform defendant Banks of the government's theory of the case to obviate the need for a bill of particulars. See United States versus Geese. It is so ordered. All right, so we got that out the way. Now let's get to what the hell y'all came for. So, basically, this is all done in chambers. Order denied defendant DeAndre Dontrell Wilson's motion to sever. And then it says, before the court are the following documents: defendant DeAndre Dontrell Wilson, motion to sever motion filed under seal on October 6, 2025. Asa Houston said, I'm doing the same thing, October 7th. Lindsay said the same thing, October 7th. The government's omnibus opposition filed under seal on October 28, 2025. Defendant DeAndre Wilson replied, support a motion to sever filed under seal on November 13, 2025. The court denies the motion. Houston joined her and Lindsay joined her. The trial is continued to August 20th, 2026 at 8:30 a.m. The government is so ordered to prepare a speedy trial act stipulation to continue the trial to this date, noting defendant Banks' objection, a legal standard. So Rule 8B provides two or more defendants may be charged with the same indictment or information if they are alleged to have participated in the same act or transaction or in the same series of acts, transactions constituting an offense of offenses. Let's just go ahead. However, Rule 14 recognizes that some joinders of defendants may result in prejudice and therefore permits a district court to grant severance of defendants if it appears that a defendant or the government is prejudiced by joinder, whether the co-defendants are to be tried jointly or severally is a question, or severely. I don't know which one that is anyways. And I don't really give a shit right now. It is late as hell. Anyways, is a question for the trial judge whose decision will not likely be overturned on appeal. 25 more federal practice. So the case law makes clear that joinder is the rule rather than the exception. And the Supreme Court cautioned that given the preference for joinder, a district court should grant a severance under Rule 14 only if there's a serious risk that a joinder would compromise the specific trial right of one of the defendants or prevent the jury from making a reliable judgment about guilt or innocence. That's such bullshit, and you should know it. That you're basically saying, oh, well, there's not going to be any spillover. Durk isn't alleged to have shot anybody or any of this crap. Y'all want to know the play for today? That QR code, free cash, win hundreds of dollars, $500 a month if you want to. Number 2 on the Apple Store, number 3 on the freaking Google Play Store, or hitting that goddamn link in the description and playing today, getting paid just to play some freaking video games. Y'all can play Nash in your background, you hear me? But soon as you put that goddamn app on your phone and sign up, we got $5 cash from Nash. Free cash, man. Sign up today. Let's get back to the content. But he's the mastermind, do the lyrics, right? All right, cool. We can't sever that. We can't just say, here's the songs and all of this shit, and that's going to make that be what it is. No. That doesn't work. No. It's bullshit, bro. It's automatic spillover. If I'm involved in a crime, but I'm not a part of the crime actually, I'm a part of saying, if you do this, you guys will be hurt. But then I make an argument that says, bro, y'all didn't switch your whole entire argument And now you're trying to basically make me seem like some crazy ass mastermind. And the judge is like, nah, I'm going to tell people this doesn't apply here and this doesn't apply here, so don't apply it. And you think that's going to work. Right now, don't think about a red hat. Don't even think about it. Don't think about this burgundy hat right now. Don't even, you see how stupid that sounds? Let's go. Roll it. Discussion. The motion argues that severance is required due to potential spillover prejudice from evidence that primarily concerns defendant Banks, including much of the evidence discussed in the court's recent Banks motion in limine. Defendant Banks, Wilson, Houston, Lindsay were indicted together for their alleged participation in the same conspiracy. Severance is especially disfavored in conspiracy trials precisely because the concern for prejudicial efficiency is less likely to be outweighed by possible prejudice to the defendants when much of the same evidence would be admissible against each. So even assuming the premise of the motion is correct, that some evidence will be admissible only against defendant Banks and not others, severance does not follow a necessary conclusion. On the contrary, the Ninth Circuit has held that the fact that separate evidence exists or is admissible for different co-defendants does not necessarily create a spillover effect that requires severance as a matter of law. Further, even when there is a risk of spillover prejudice, less drastic measures than severance, such as limiting instructions, often will suffice to cure any risk of prejudice, which is bullshit. So basically, a judge gonna come out his mouth and say, yo, this only applies to these people. Do not apply this to this person. Like, come on, bro. They gonna do that shit. That's human nature. F out of here, bro. Repeatedly held that a district court's careful and frequent limiting instructions to the jury explaining how and against whom certain evidence may be considered can reduce or eliminate any possibility of prejudice arising from a joint trial. Right. District court did not abuse discretion when it instructed the jury that it had a responsibility to keep the evidence against two defendants separate and give due and separate consideration to each. Which, once again, it is beyond difficult. It's beyond difficult for you to sit me next to killers and say, yeah, all this evidence is for them and find them guilty, but then find my orchestration of it all. But the brutality that they have is not supposed to be applied to me. What? Nah, bro. We ain't doing that. Nah. That judge know what he doing, bro. He wasn't gonna grant that shit. The fact that Drew went over his head and tried to go and talk to other Supreme Court justices and all of this shit and go up the ladder, which they're gonna have to do now. So it is what it is. Here, the motion does not successfully demonstrate the insufficiency of limiting instructions, which is necessary to sever a trial based on a punitive spillover effect. And while some of the evidence focuses solely on defendant Banks and may require limiting instructions, none of that evidence is so egregious or voluminous that it would prevent the jury from making a reliable judgment about guilt or innocence. So, as counsel, no doubt realized the motion was considerably stronger before the government's withdrawal of the Chicago incident. Oh, shit. As evidence purportedly admissible under Rule 404B or as inextricably intertwined. I like saying that phrase. I don't know why. The court pondered whether this might be the rare case in which severance should be ordered in its discretion rather than because the denial would be an abuse of discretion. The reasons supporting discretionary severance, the merit of Mr. Wilson's arguments, even if far from sufficient to require severance and regrettable delay of defendant Banks' trial, outweighing those reasons by a wide margin, are the dictates of case law and co-conspirators be tried together. Not reviewable, of course, but a severance here might have been an abuse of discretion the other way, and that there would be only a very small simplification of either trial, and thus little benefit to the jury. Accordingly, the motion is denied. The trial is continued to Thursday, August 20th, 2026 at 8:30 a.m. The government is ordered to prepare a speedy trial act stipulation to continue the trial to this date, noting defendant Banks' objection. It is so ordered. I'm gonna say something that's seem pro-Fed as hell, so it is what it is. When I don't have a side in this, I know I get tasked with a lot of things where people try to say, "Yo, Seti Nash, you pay by OTF and all this shit, and you drop Quando Rondo's location on purpose." No, the hell I didn't. I ain't do that shit on purpose. So it is what it is. Um, I'm cleared, by the way. Just want y'all to know that. Uh, if the feds anticipated that if we apply, meaning the feds, if we apply the shooting in Chicago and try to make that a thing, we would have actually hurt the damn people in the case against Lil Pab and Quando Rondo, which is insane. That is some next level thinking as far as lawyer work. I'm just gonna be honest. Like, you can look at your, I'm not gonna say my ops because I ain't got no goddamn ops. The feds ain't my ops. It's F the feds for sure, but they ain't my ops like that. I mean F the feds as an institution and how they terrorize people and all that. And I don't believe that they're doing application of the law fairly and correctly. I think about 50% of the cases that they do is to help out the government in a positive way, like get certain people off the streets, which I'm not against, but 50% of the other shit is really just bullying and antagonistic tactics, in my opinion, based off of a lot of shit that I read. But I wish no harm against the feds or nothing like that, because I don't want to pull up to that goddamn trial and how you cats snatch me and throw me in the back room and start questioning me like y'all about to give me 20 years in the feds, and then y'all get spanked legally by law because y'all don't know what the hell y'all talking about. And I witnessed this my goddamn self. But to the point at hand, bruh, that same argument that they just made could be the same argument that is made as far as the shooting that happened in Georgia. Now, if I'm an arguing man, which I typically am, I would say, no, Nash, this is two different cases. But they try to, meaning the feds try to paint it as, oh, this is a pattern of behavior. This is what Durk does. If you hurt somebody that he rocks with, bruh, they gonna come at you. They gonna shoot at you. They gonna do this. They gonna do that. That's why the Stephon Max shooting doesn't make sense that it didn't come in. But the judge said, had the feds decided to bring that in, bruh, I was gonna sever the goddamn case. Which means either they did some exceptional work, which I don't believe, or the judge tipped them off. I'm gonna believe the judge tipped off the feds. Like, hey, if y'all stick the Stephon Max shit on here, bruh, I'm gonna have to sever Durk's case, and y'all gonna have to see Big Bad Drew, and it's not gonna go in y'all favor. That's what I believe. Me personally. That's what I believe. But it don't matter what I believe. Nash, is this good or bad for Durk? This is bad for Durk. This is a big ass L. Not only that, when you didn't get the bill of particulars, like you trying to figure out how the hell you want to fight certain things and all this shit, it's best if you already get it done. But not only if you get it done, you have a head start on this shit. And it's even more bad, meaning it's more bad because you can tell this is an active investigation of let's throw shit to the goddamn wall and see what sticks. Because it used to be, oh, we got flight logs, we got text message threads, and we have cooperating witnesses, and we had 2 songs. Now it's all about we got 10 songs, and these niggas is bouncing ass in the back, and that's what makes them all co-conspirators because they were being backup dancers in a music video by Lil Durk. That's the reason why. But you don't have any paperwork that shows these guys were going to be signed to anything. Like, so remember, it was August 2022 where Lil Pab gets killed. Then fast forward 2 years later, that's when you see Lil Durk get freaking arrested for all this stuff and all this people and all this shit. So it's 2 years later. At what point in time did these cats wait 24 damn months and say, Durk, hey, sign us. Where's my album at? So you mean to tell me these cats just did all this shit to be backup dancers? Yeah, it doesn't make sense. Here's my real belief. that the feds are convinced that they're informants, that they're snitches, that their people that they have made the case for them, and they're like, F it. If we lose, we lose. We're going to get the 4 that we wanted. But that fifth one, we going to go ahead and put some icing on that shit. Some sprinkles on that goddamn thing. That ain't icing. That's supposed to be sprinkles. My bad. That's what I believe is going on. I believe that the feds are so hungry and so desperate on some bullshit that they did not care. And they do not care. If they get it wrong, what happens? If the feds actually find out that they lose at the end of this shit with trying to convict Lil Durk, if that's what happens, right? What happens to them? Nothing. Because they're going to hang their head on this. They're going to say, oh, well, we got the other 4. And y'all don't hear me saying, and this has to be stated, you don't hear me talking about the alleged shooters and none of this shit saying these cats is innocent. I ain't said that not once. That's not me saying that. I'm saying I don't believe Durk mastermind this shit. That's where I start and stop at. That's it. So when I see this shit, it's like, y'all switched your theories up. Y'all said there was money dropped, and there was no money dropped. And then now, all of a sudden, it's all about music opportunities, but the music opportunities was to stand in the background in music videos. No songs, no record deals, no advancements, no nothing. Then when y'all did the deep dive on this shit, y'all had nothing. And y'all know as well as we do with the Alicia Andrews trial that Apple will give them every goddamn thing for the last 20, 30, 40 effing years. And they went through and they did it. See, this is bad for Lil Durk because it allows the damn government to keep on making up bullshit. I don't believe anybody in Durk's case is snitching as far as those who are involved in this shit. And even if they are, what can they absolutely say? See, what would have had to have happened was this. In the beginning, God created heaven and earth. Now, in the beginning, somebody involved with the case would have had to have been arrested, and the feds just picked them up, and then basically they started to rat. But that would have took like a month, so nobody ever alleges that, oh shit, these guys are just out here chilling. 4 out of 5 of them were chilling. That 5th one been in jail. That's not a thing. So that's why I don't believe there's cats in here that's snitching. Will they have the opportunity to snitch? Hell yeah. Hell yeah. You don't think the feds ain't finna... Here's a statement we wrote for you. The facts that we got for you. We just want you to sign right here. Sign. 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 I don't know, man. Share to keep your people aware. Subscribe to our best and notified, and I'll catch you on the next one. These 2 right here, man. We giving them away. 24K away for that giveaway. So subscribe today, comment today, share today, like today, and I'll catch you on the next one.